Welcome to Civil Justice for SA Survivors.
Welcome to Civil Justice for SA Survivors with attorney Marc Pearlman and Melissa Anderson. Marc and Melissa represent survivors of SA, or sexual assault and exploitation in Illinois. Focusing on civil accountability and institutional responsibility, I'm Lisa Mosby, your host. And today we're talking about what evidence looks like in a civil SA case and how civil courts evaluate proof differently than what many people expect. Thanks for being with me today, Marc and Melissa.
Thank you.
Hey, Lisa.
Can you explain what qualifies as evidence in a civil SA case and how civil courts evaluate that?
It's often not what our clients, when they first call in, would think in terms of what the focus is, in terms of what needs to be proven in our process. Often they think of more of the criminal process when they think about justice in the legal system, and they often think of proving a sexual assault or proving SA, and that's often what they think is going to happen in the civil process. And obviously, the standard of proof in a criminal case is much different than a civil case, but often the focus in a criminal action is evidence, physical evidence proving that an SA happened. And when they come to us, a lot of our focus, what we explain to them from the outset is our focus is typically on pursuing an institution that protected or enabled SA to take place. So our focus is a lot less focused on proof of the SA and the incident of abuse. And a lot of our proof goes into what the institution knew or should have known. And so a lot of that is evidence that is outside the control of the survivor, but outside of our control and what our client has to make available. And it's really a matter of seeking documents and information and testimony from individuals at the institution and getting to the bottom of how the institution was structured to prevent SA, what was done to try to prevent SA, and what was known to them in terms of information that they should have taken and acted in a way to have prevented the SA. So in terms of the type of evidence and what the focus is in a civil action is often very different than what our clients think it's going to be when they come forward. A lot of our clients are very concerned about 100% of their case hinging on whether or not they have evidence of the SA. And oftentimes that's daunting for them because it goes back, sometimes 3-4 decades. And they say, I don't even have proof that I was where I said I was when this happened. And so that's not usually what our main focus is. Obviously there's an element of that to any case. In terms of proof and establishing that. Often that can be established by just testimony of witnesses in terms of our client being the main witness and testifying about what had happened to them. So that's the types of evidence that in terms of proof, what our focus is often very different than what somebody thinks it's going to be when they come forward. And in terms of the burden individually being on them proving that this happened to them.
And then in civil cases involving institutions, can you be a little bit more specific on what kinds of records or documentation often end up being important?
Sure. So it could range, it's broad. Discovery and what we're entitled to get from the institution is very broad, but it typically involves things like their employment records, where they were assigned, what dates they were assigned there, communications from parishioners who may have written and expressed concerns about a particular priest in the case of the Catholic Church or other religious superior. And, in education cases, again, the teacher's employment and any complaints. So it's typically all of their business records ultimately become available to us to see what they did to prevent SA from occurring from a supervisory role, and then whether they knew about any SA or things that suggested there may be SA in the workplace environment.
And looking at things like what policies and procedures did an institution, an employer, or a youth center, what policies and procedures did this institution have in place, written policies and procedures, and what documentation do they have to show that they followed those policies and procedures? What did they do? What can people at the institution testify that they did to ensure that those policies and procedures were followed? It's shocking how often those policies and procedures that institutions have, that they're nothing more than a piece of paper that nobody, including those in charge, have any idea of how to enforce. And there's often, sadly, it's often just window dressing in terms of what they say they're going to do with no follow through. So that's why it's so important, I believe, for everyone in these situations to come forward, because it's important, particularly in what most of our cases involve, which is children. It's just so important. It's not enough to have these policies and procedures in place. It's just to protect kids, to know that something's actually being done to make sure that those are followed.
And it seems like there's patterns or inconsistencies in these organizations. How do patterns, rather than a single isolated incident, factor into how a civil case might be evaluated?
Sure. Well, that's a really good question, because patterns often in criminal cases, it may be inadmissible because the focus is really on the particular crime at issue, and sometimes admitting patterns could be prejudicial to a criminal defendant. In the civil case, really what we're required to prove with respect to the institution is that they knew or should have known that this was a dangerous situation. So patterns are critical, because that shows either what the institution knew or what they should have known. So admissibility of pattern evidence is much more common in a civil case than a criminal case.
And time always matters, but time often plays a role in these cases. How does civil court account for the reality that information records and disclosures may emerge years later?
It's tricky. Part of, in the justice system is the finality of it. So it's obviously, once the case is over, it's over. There's no going back and getting a second stab at something. But in terms of the timing and when things happen, sometimes a lot of evidence relied upon as experts who can opine as to what they believe will happen in the future based on past behavior. A lot of times that's more common in the sense of how a particular client has been damaged by what's happened by the SA. So, an example is an expert who's either who has experience in the particular field about how throughout someone's life, how SA will impact them 10, 15, 20 years down the road. And that's, yes, you don't have documentation of what things are going to be like, but you do have experts who can opine as to what the future might look like for particular things.
And then with respect to the institutions, as we've just talked about, the past is a pretty good indication of the future. So you can say to a jury or argue to a jury, well, look, unless you do something that's going to make this institution stop doing what they've been doing historically, then the future is going to be as dangerous as the past for children or for vulnerable adults.
When physical or forensic evidence isn't available, what other forms of corroboration can still matter in a civil case?
Yeah, in terms of when you think of forensic evidence, what you're really usually thinking of is, did this happen? Was there an SA involved here? And across the board, that's usually not available anymore. Sadly, because we know how long it takes a survivor of SA to come forward. you know, if survivors come forward, it's often decades. So a lot of our clients who were abused when they were, a teenager are now 50 years old. So clearly there's not going to be, you'd be surprised. There sometimes is some physical evidence that our clients have, but it often becomes almost irrelevant in our case because a lot of times what's relied upon is oral testimony from our clients about what happened to them. And then often what we do rely on. So yeah, you don't have necessarily forensic evidence, physical evidence that there was an essay that took place, but you have our clients' testimony about what happened to them, or you have testimony from other people who were at the institution at the time and knew how things went. For example, a school. We've had cases where people are there to testify. Yes, this person, despite our policies and procedures in place, this particular adult often took students behind closed doors, alone, one-on-one, when it was against the policies and procedures and there was no legitimate reason for this happening. Testimony like that makes, if you have a certain amount of testimony establishing to corroborate what our clients have said, it further bolsters the argument that this did in fact happen. It's left up to a jury to evaluate the strength of that evidence. But if there's oftentimes, sadly, documentation that we get in the course of discovery that shows this school, for example, had other cases where people had complained about a particular teacher being sexually inappropriate with a student, and that's in their records. That is something that, obviously there's arguments both ways, but that's something we argue to have admitted into the case, because at some point, even if you don't have definitive proof from a physical standpoint, the scale's tipped where you have enough to establish a pattern of behavior or other witnesses to corroborate the circumstances surrounding a particular SA. That could be enough. So not having, it's sad because often I think people don't come forward because they don't have definitive proof of something happening. And that's something we, from the outset, it's very clear that that's often a huge concern of our clients when they come forward, is that they're not going to be believed because they don't have physical proof of what's happened to them. So that's something we try to assure them from the outset. It's not as big of a hurdle as they might think.
And in fact, the vast majority of cases are based on what I'll call circumstantial evidence, not, DNA or clothing that has, DNA on it or what have you. So these cases are really determined more often than not based on circumstantial evidence and testimony regarding what was happening at an institution and what the policies were of that institution. Was the institution following those policies?
So from a legal standpoint, why is consistency over time something, or sometimes more important than one specific piece of proof?
No, I just think it's human nature, right? But these are juries who are going to be deciding these cases. And I think most people believe that if 90% of the time you're doing X, later, is it more likely you're going to do X or Y? And most people would say X.
Yeah. If you've got a policy in place that an institution admittedly says was put in place to prevent child SA, so they've put that in place for that particular reason. You have a consistent record of not following the policy, knowing that the result of not following the policy is that children are going to be in danger. You show consistently over time that that's what they've done, and the result was a child being abused. Then it's again, it becomes that much easier for a jury to understand that that's what happened in this case as well.
Or oftentimes, let's say an institution has a handbook about sexual harassment, sexual exploitation, sexual abuse, or SA. And we start deposing or questioning people about, were they aware of the handbook and those provisions? And when 90% of them say no, or everybody says no except the head of our HR, then that's pretty indicative of the fact that that policy existing was inconsequential because nobody knew about it.
You've explained it really well, how you pull in policies and emails and documentation and complaints from other folks, how that can start to corroborate that there doesn't have to necessarily be physical or forensic evidence. And that makes complete sense to me. For people trying to understand whether a civil case is even possible, what's most important to know about how evidence is evaluated as a whole rather than its isolation? How do we really drive this home for folks that are on the fence and maybe need to be coming forward but are unsure?
What I would say is, if the question is, do I come forward or not? I would say don't focus on the evidentiary issues. That's let the lawyers who this is their job to do that. If you are suffering in silence from SA, you should call a lawyer if it's something that you're prepared and ready to do. And everybody comes forward at their own pace. You should call a lawyer and get advice. And if you get that advice and you don't like it, call another lawyer. I often say therapists and lawyers are like shoes. Sometimes you have to try on a lot of pairs before it feels comfortable.
I understand that completely. Any final thoughts for today's episode that either of you would like to share with our audience?
And Marc said, in terms of making the call if you're ready, and I would stress that when we say if you're ready, it means you don't have to be ready to put your name out there. You don't have to be ready to file a lawsuit, and you don't even have to be ready to pursue a claim. But making that call, I want to say never had a client that we've taken that said, I'm disappointed that I ever even picked up the phone, because there's so many options once you do. And an initial call or even the first 10 calls, I can't remember having a conversation with a client where I'm talking to them about lack of evidence. That's, like Marc said, that's our job to put that together, that whether or not, even the lawyers who do take your case, you don't know what your evidence is going to look like for a really long time. And that's not something that somebody who's calling in to talk about SA, that should not be their focus. That their focus should simply be the hope that when they make that call, that they will feel better after they did for having made that call. And from our experience, that's typically the case.
Another thing that I think is really critical for survivors of SA, and I call them survivors, not victims, because that's what they are. They're survivors. But mostly, they often believe that what they're experiencing is unique to them. Like that they're the only one that feels that way. And the truth of the matter is, almost all survivors of SA have those same feelings and those same thoughts. So, for example, I would say we have hundreds of clients, that have said that they picked up the phone to call us, 50 times and dialed every digit but the last one and hung up. And that it took them a year to finally hit all the digits and get us on the phone. So it's really common. A lot of what our clients experience in their life because of the SA, many of them go, this is so bizarre. I have to be the only person that's experiencing this. And the truth of the matter is we have a lot of experience, and we could say to them, we can't talk about a particular person or their case, but we could say many of our clients feel that same way. Many of our clients experience that. And that's nobody wants anybody else to experience those things, but it's comforting to know you're not the only one.
And we'll leave it there for today's episode. Thank you, Marc. Thank you, Melissa, for being with me. That's it for today's episode of Civil Justice for SA Survivors. To learn more about Marc Pearlman and Melissa Anderson and their work representing survivors through the civil justice system in Illinois, please visit pearlmananderson.com. Thanks for listening. And if you found this episode helpful, please subscribe and share it with someone who may benefit from the information.
Thank you, Lisa.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.